Hello, and welcome to today's webinar on 2019 Employment Law Updates, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at aspenrmg.com/Heffernan-webinars. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the questions box or the chat box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will try to work your questions or feedback into the end of the presentation. If we can't get to your comment or question during the presentation, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, 2019 Employment Law Update. Today's interactive session will be facilitated by Miranda Watkins. Miranda Watkins is an associate in Fisher & Phillips LLP San Diego office. Her practice includes counseling and defending employers in all areas of labor and employment law. Before joining Fisher Phillips, Miranda worked as an associate attorney for a national law firm focusing on employment and general civil litigation matters. Please enjoy your session today.
Thank you, and thanks everyone for calling in today. I just want to make a quick note that although this presentation is entitled New California Laws for 2019, a lot of what we're going to be talking about is actually federally based. So for those of you who might operate outside of California as well, there's still going to be a lot here for you to want to pay attention to. But there were a lot of changes in California that I think we're going to see as trends in other states as well. So I've put together a pretty robust presentation for you all today. Hopefully you will find it informative, and please feel free at the end to ask me any questions you might have. And if we don't have time to get to everybody's questions, I'm more than happy to answer questions offline after the fact. Now, as the moderator said, I do labor and employment law, and Fisher Phillips is a firm that only does labor and employment law as well. So we're really specialized in this one area of law. Now, even underneath the labor and employment umbrella, there's a lot of different sort of sub areas that fall under that. I primarily defend employers in employment lawsuits, but I also do a lot of advice and counseling work as well. What that entails in a nutshell is essentially me walking you through or answering questions about anything that relates to the employment process. So that can be hiring, firing, disciplining employees, investigating employees. I can walk you through all that. I can answer questions about that. I can also prepare all the documentations that you would need to go through those processes. So with that being said, I think today will hopefully give you a good overview of what to look out for in 2019. I'm going to try and end the presentation with some practical tips for you all. So hopefully you can actually take something away and go back to your employer with some to-dos or things to look out for this year. So with that being said, let's jump right in. So in 2018, at least in California, we saw a lot of movement in the legislature. There were over 2,200 bills introduced last year. Just over 1,000 made it through the legislative process and were actually sent to the governor. 83.5% of those were actually signed into law, and then 16.5% were vetoed. So here's our quick overview of those bills. Basically, I think it's pretty easy to split them up into two main categories: #MeToo bills and everything else. The vast majority of bills introduced, at least in California this year, were focused on or stemmed from the Me Too movement. And then lastly, we'll talk about what do you do with all of this information. So as I mentioned, the Me Too bill definitely dominated 2018 in California. 2018 was definitely the year of the Me Too movement and the Weinstein effect. So I'm sure you all have heard about Me Too ad nauseum at this point. But for those of you who may not be as familiar, Me Too was essentially a movement that went viral that stemmed from Harvey Weinstein, who was a bigwig Hollywood executive, being accused by many, many, many women of sexual harassment, sexual assault, and that sort of snowballed into a lot of men and some women, not just in Hollywood, but across various industries, including politicians, the news industry. Matt Lauer was one of the men who sort of got roped into this Me Too movement, being accused of past sexual harassment and or sexual assault. So I definitely think employers should expect to see an increase in the number of sexual harassment complaints and claims this year, particularly in California, and also an increase in the amount of money that it's going to take to settle these claims. Now, the reason for that is because Me Too became such a big deal and such a hot topic in 2018, a lot of jurors are really fed up and they're not giving the benefit of the doubt to employers and or alleged harassers anymore. And so that makes this really scary. That coupled with a lot of the legislative changes we saw, at least in California in 2018, have resulted in an increase in the amount of money to settle these types of claims. So first off, in California, we saw the passage of SB 1343 regarding sexual harassment prevention training. I'm sure those of you who operate in California were already familiar with AB 1825, which required employers with 50 or more employees to train their supervisors on sexual harassment prevention. And that training was 2 hours of training that you were required to give your supervisors every 2 years. SB 1343 takes that a step further in two different ways. So one of which is SB 1343 extends this obligation to smaller employers, and it also requires training for all employees, not just your supervisors. So under SB 1343, if you have 5 or more employees, you are now required to provide sexual harassment prevention training. So that's going to encapsulate probably the vast majority, if not all of you. And now training is required for all employees, not just supervisors, but there is a difference in the amount of training. So your supervisors are still going to get 2 hours of training every 2 years. Your non-supervisors only have to have 1 hour of training. However, this law states that by January 1, 2020, employers have to do this. And so the 2 years basically starts over again. So for those of you who may have trained your employees last year and think you can just wait again, that's not the case. You're going to have to retrain them this year, and then you're also going to have to retrain your non-supervisors with 1 hour of training. And then after this year, every 2-year requirement starts over again. In terms of options as to how to go about doing this training, the Department of Fair Employment and Housing has indicated that they are putting together a video training option. Last time I checked, this was not finished yet. So it's a little bit tough for me to evaluate the effectiveness of this as an option for you all to use. I don't love the idea of recommending employers to use DFEH video training for one big reason, which is when you think about what the purpose of the DFEH is, it's to protect employees, not help employers. So there's a bit of an implicit bias that I think underscores a lot of the DFEH materials that I've seen in the past. So until I'm able to take a look at this, I wouldn't recommend this option. There are still lots of other options. You can hire an outside person to come in and do your trainings. Our law firm does these trainings, for example, and there are lots of other organizations that offer video options that I would be happy to talk through with anybody, but I just wanted you to know that that's out there. There are also some special rules for seasonal, temporary, and agriculture workers that I'll just leave there for you all to look at if you fall under that particular industry. But in the interest of time, I won't belabor that point too much. So aside from that bill, we also saw the passage of the STAND Act, or SB 820. So the Me Too movement has focused on non-disclosure agreements, or quote unquote secret settlements involving sexual harassment claims. This was a big deal, particularly with Harvey Weinstein, because it came out that he had settled with a lot of these victims in the past, but he had required them to sign non-disclosure agreements, or NDAs, which arguably led to him being able to sort of continue engaging in this behavior and continuing to sexually harass and or sexually assault many, many, many women, because none of them could talk about it. So critics contend that these clauses keep these claims secret and allow perpetrators to continue harassing their victims. So the STAND Act prohibits confidentiality or non-disclosure clauses in any settlement agreements that involve sexual harassment, sexual assault, or, and I think this is really surprising to a lot of people, any claims involving workplace discrimination that's based on sex or failure to prevent harassment or discrimination or retaliation based on sex. So the tough part about navigating around the STAND Act now is, how do you structure your settlements if you have claims involving sexual harassment or assault or the other miscellaneous claims listed on this slide? Now, this law just took effect about a month and a half ago on January 1st. I had a case that actually went to mediation about a week after this law took effect, and it was a sexual harassment case. We also had discrimination based on sex, retaliation, failure to prevent, those claims as well, in addition to a whole host of other claims. The way that we chose to structure the settlement there was to create 2 settlement agreements. One settlement agreement did contain confidentiality provisions for all of the non-sexual harassment related claims. The non-confidential agreement covered the sexual harassment and related claims. So the bit of difficulty there, in addition to that, was figuring out how do you allocate the settlement amount, because whatever amount goes into the non-confidential agreement theoretically could be leaked. There are lots of different ways that other attorneys are trying to work around this STAND Act, but it's concerning for you as an employer, because essentially what it means is when you settle sexual harassment claims, you can't prohibit that plaintiff from running to the media or, putting stuff on social media and online about their claims because you can't require confidentiality. So it's a little scary. So it still kind of remains to be seen if this will be challenged at all in court. But for right now, that's one way that we have come up with to try and get around this. The plaintiff can still ask for confidentiality under this bill, but that's only if they want it. So if they don't want it, you can't require it. It does not prohibit a provision that precludes the disclosure of the amount paid in the settlement of a claim. So you can still try to keep that confidential. And this doesn't cover pre-litigation settlement agreements. So this might give those of you who might be dealing with existing pre-litigation sexual harassment claims a bit more incentive to try and get those settled before an actual lawsuit is filed, because at that point, you won't be able to require confidentiality anymore. Okay, another bill that we saw passed this last year in California was SB 1300. I kind of jokingly refer to this as the mother of all Me Too bills, because it literally was just like everything in the kitchen sink thrown into this bill. Each item is essentially from a plaintiff's attorney's wish list. So this is a big bill and one that was not good for California employers. So first off, it placed limitations on releases and non-disparagement clauses. This bill makes it unlawful for employers in exchange for a raise or bonus, or as a condition of employment or continued employment, to require an employee to sign a release under the Fair Employment and Housing Act. This is not targeted specifically at sexual harassment claims, but this stems from the Me Too movement. It also prohibits an employer under the same conditions from requiring an employee to sign a non-disparagement agreement or any other document that tries to deny the employee the right to disclose information about any unlawful acts. This, however, does not apply to bona fide negotiated settlement agreements. The question here is, does this apply to severance agreements? On the one hand, even though a severance agreement usually is being negotiated at the end of somebody's employment, usually they're signing it before they're actually terminated. So arguably, this is something that's being asked for as a condition of employment or continued employment. Our firm has, I think, largely taken the position that this probably would not cover severance agreements, but it's possible that a court might interpret it differently. So that's something to keep in mind. SB 1300 also places limitations on prevailing employers' rights to fees and costs, which is never great, right? The laws in California are very one-sided. So employees have a lot of incentive to push their claims forward and push them closer and closer to trial, because if they win even $1 at trial, they get their attorney's fees paid for by the defendant, the employer. The reverse is not true. So a prevailing defendant in a Fair Employment and Housing Act action will only be entitled to attorney's fees and costs if a court finds that the plaintiff's action was frivolous, unreasonable, or totally without foundation when they brought it. That is a really, really tough standard to meet, especially in these he said, she said cases where you can't really disprove their claims. I think this bill makes it almost impossible for an employer to ever recover their own attorney's fees and costs. This also applies to Section 998 offers of settlement, which is a little bit scary too. This bill also provides for expanded harassment liability for third parties. So existing law provides that employers can be held responsible for sexual harassment committed by non-employees if you knew or should have known that this conduct was taking place and failed to take immediate and appropriate corrective action. This bill extends this potential liability to all forms of harassment, not just sexual harassment. Because of that, SB 1300 sort of recommends optional bystander intervention training. It's a bit odd because this bill states that employers may provide bystander intervention training. I think based on the expanded potential liability for third-party harassment, bystander intervention training should probably be something you're just doing now as a pattern and practice. You have to train your non-supervisors anyway. You might as well train them on what to look out for when it comes to harassment by third parties. SB 1300 also interestingly provides a lot of legislative guidance to the courts, so to speak. So all the bullet points listed on here are not it's not language that's contained in the bill itself. These are contained essentially in the notes or the legislative history for this bill. So on the one hand, arguably, courts do not have to abide by any of this language or recommendations. On the other hand, you might have some judges that would take this into account and would listen to this. So for example, SB 1300 sort of implies that a single incident of harassing conduct is sufficient for a hostile work environment claim. The standard up till now has been that a plaintiff has to prove severe or pervasive harassment. Severe harassment could be something that happens once, but it's really, really serious. On the flip side, pervasive harassment is something that likely in and of itself is not all that serious, but if it happens frequently enough, that can become pervasive harassment. This language seems to indicate that we're not operating under the severe pervasive standard anymore, and that one single incident of harassing conduct, whether it's severe or not, could be enough evidence for a harassment claim. This bill also implies that summary judgment is rarely appropriate for sexual harassment claims. This is a bit scary as well. Summary judgment is something that employers really rely on to try and get rid of cases before they go to trial, or at least get rid of some of the claims before you go to trial. I think this is going to embolden a lot of plaintiffs' attorneys to not only bring more sexual harassment claims, but to push those claims further on down the line, because they're going to feel like the employer doesn't have a legitimate shot at getting rid of this entire case on summary judgment. So now the employer's option is to either settle or go to trial. I won't go over the other two too much in the interest of time. I think they're pretty self-explanatory. I did want to quickly mention that this bill implies that the standard for what constitutes a valid sexual harassment claim does not vary by the type of workplace. For those of you who might be familiar with the case involving a Friends TV show writer, that case seemed to indicate that because of the nature of that type of workplace, the behavior that the plaintiff was complaining about was not harassment. This makes it a bit scary because not every workplace is the same. Not every workplace engages in the same type of business or operates in the same way. But this bill seems to imply that regardless of what type of company you are or what kind of operations you engage in, the standard for what constitutes sexual harassment is going to be the same for everyone. We also saw some protection against defamation for California employers via AB 2770. This was meant to codify California case law as it relates to allegations of workplace sexual harassment. So this bill, let's go back to that. This bill essentially protects both employees and employers. On the one hand, it protects employees who might complain about sexual harassment from being sued for defamation based on that claim, as long as it's made based on credible evidence and without any malice. And then on the flip side, it protects employers from being sued for defamation in trying to defend itself against those claims or investigate those claims. We also saw SB 826 pass regarding boards of directors. This law states that by 2019, a publicly held corporation with offices in California, principal offices in California, needs to have at least one female director on its board. Now, the definition of female includes those who self-identify as female regardless of sex at birth. And then by 2021, there's sort of increased minimum numbers based on how big your board of directors is. So I don't want this to be all doom and gloom. It definitely could have been a lot worse. Governor Brown did veto a lot of other really big Me Too bills that I think would have been really detrimental to employers if they had passed. One of which was AB 3080, which would have prevented employers from requiring employees to sign arbitration agreements as a condition of employment. This would have gutted, essentially, employers' ability to one, keep claims, especially sexual harassment claims, from being tried in the public eye. You know, courts are public, arbitrations are not. This would have also made it really difficult for employers to combat class actions because without arbitration agreements with class action waivers, it makes it more likely that you will get sued for class actions. AB 1870 would have extended the period for filing administrative claims from 1 year to 3 years. This would have been huge as well. Currently, if an employee in California wants to sue you for something like discrimination, they have to file an administrative complaint with either the DFEH or the EEOC within a year from when that behavior took place. They have to get a right to sue letter, and then they can go sue you in court. I think if this bill would have passed, it would have made an employer's ability to defend itself really, really difficult. A lot of employment law claims are just by their very nature, he said, she said. It's already difficult enough to deal with trying to rely on witness memories going back 1 year. Going back 3 years, I think, would have been nearly impossible. Not to mention that a lot of employees these days bounce around to different employers, right? A lot of people don't stay put in one place for all that long anymore. If an employee had the ability to go back 3 years and sue you for something that happened 3 years prior, it would be very likely that none of those witnesses would even work for you anymore. And good luck trying to find them and getting them to cooperate with you at that point in time. So I think it's a really good thing that that particular bill didn't pass. There was a bill that didn't pass regarding record retention, and then AB 3081 would have made employers and labor contractors jointly liable for sexual harassment. That also did not pass. I do think we should keep our eye out to see if these types of measures or something similar will be back this year. I suspect they will. I suspect we're going to start seeing other states kind of jumping on this bandwagon as well. So keep your eye out. Okay, now that we've gone through kind of all the Me Too bills, the runner-up is really everything else. So there were a lot of other employment measures signed into law in California last year. One regarding lactation accommodation, AB 1976. Prior to this bill, California law required employers to provide a location for lactation accommodations other than a toilet stall. This particular bill requires it to be a room other than a bathroom. There is a limited hardship exemption that you can apply for from the DIR. It does allow for temporary locations that are free from intrusion and meet various other conditions. So I have seen some employers kind of put up these kind of pop-up pumping stations, so to speak, but just know that that's out there now. AB 2282 tried to clarify some of the key terms and gray areas that came out of AB 168 from the prior year relating to salary history bans. Salary history bans are definitely still a trend, and we're seeing more and more states enact various iterations of a salary history ban. So this gives you a good overview of some of the questions we were getting after AB 168 passed in 2017 that sort of clarifies what this law means. SB 1402 discusses port trucking joint liability. Now, I think this bill has a lot bigger reach than people realize. So essentially, what will happen now is the DLSE will compile and post a blacklist of port trucking companies that have unpaid judgments against them. And this could be anything from a failure to pay wages, a failure to pay workers' comp insurance, things like that. Any customer who contracts with a company who ends up on that blacklist can be jointly and severally liable for any future claims. That is really, really, really scary. And this, I think, has the potential to affect many different types of industries, like retailers, car dealers, agricultural companies, and a lot more beyond that. So a customer is defined to mean a business that engages or uses a port trucking company to perform services on their behalf. There are some exceptions, but the definition of customer is pretty broad. There are some notice requirements. So the actual port trucking company is supposed to give you notice of any unsatisfied judgments against them. However, their failure to do that does not absolve you of your potential joint and several liability. Scary, right? So some tips for those of you who might even think that you might fall under this definition. I think you're going to have to develop some protocols for how to monitor this blacklist yourself. Instead of relying on these port trucking companies to notify you about unpaid judgments, I think you need to proactively monitor to see if any of your contractors fall on that list. I think you need to build in disclosure and notification requirements or other types of due diligence measures into your contracts with those port trucking companies. And I think that there needs to be contract indemnification provisions and other similar types of methods to minimize potential liability when you're dealing with these companies. With SB 1252, this addressed payroll records. The law prior to this bill provided that current and former employees have the right to inspect and copy their payroll records. Some people were saying that employers were interpreting this to mean the employee had to bring the actual equipment and copy their own records. This bill clarifies that that's not the case. They have the right to inspect or receive a copy of those records. We also saw AB 2334 sort of address this messiness that we've seen with Obama's OSHA workplace injuries and illness rule. The Trump administration suspended the deadline for that and announced plans for a revised rule. We've yet to see that. This bill would require Cal OSHA to monitor and convene an advisory committee if the federal government eliminates or diminishes this proposal. We also saw union employers get special treatment through various types of bills that unfortunately we won't have time to really go in today, but if those of you who are unionized have questions about that, please feel free to reach out. These bills basically could potentially provide some real relief to unionized employers, but it also seems like a sort of thinly veiled attempt to try and encourage employers to unionize. Okay, so now let's jump into some of the big cases we saw come out of 2018, and not just in California, but federal cases as well. So the first of which deals with employee versus independent contractor issues. And this was the Dynamex case. A lot of you probably heard about this. This is a California-only case. So for those of you who practice or operate outside California, you don't really have to worry about this yet, unless other states start to adopt this rule as well. So the Dynamex case changes the test for independent contractors for purposes of the wage orders. The good news is that the standard is arguably more simple now and more clear, but the bad news is the California Supreme Court might have just done away with independent contractors as a category altogether, which is sort of turning a lot of industries on their heads. So industries like real estate, technology, education, for sure the gig economy are kind of scratching their heads as to what to do with this case. So the issues concern compliance with wages, hours, and working conditions for employees, taxes, like who's going to pay for this, does it give employers a business advantage to classify somebody as an independent contractor versus an employee, and what are the industry standards? So the old test that we operated under before Dynamex was called the Borello test. This test essentially boiled down to who had more control, the quote unquote independent contractor or the employer. The more control the employer had, the more that worker was arguably properly classified as an employee versus an independent contractor, and then vice versa. The less control that an employer had over the worker, the more likely it was that worker was properly classified as an independent contractor. There was a whole host of other factors that we would take into account as well, and I'm not going to read all of those to you. You can see them on these few slides here. That was the old test. It was messy because you can see how many different factors we have to consider. And courts basically said no one factor was determinative. Courts would look at this in a totality sort of basis. So they would look at all of these factors, see what was present there, weigh who had more control, and then make a final determination. So there's a lot of gray area with the old test. So now moving into the facts underlying the Dynamex case. Dynamex is a nationwide package and document delivery company that offers on-demand, same-day pickup and delivery to individuals and businesses. Dynamex's drivers were free to set their own schedule, but had to let Dynamex know of the days that they planned to work. The drivers were then assigned deliveries by dispatchers, and there was no guarantee of an assignment. The delivery drivers eventually brought a class action for wage violations, and the decision was made on a class certification motion. So looking at the suffer or permit test under the labor code, the Dynamex court adopted a quote unquote ABC test. So the court basically said, we're going to assume that the worker is an employee unless they meet A, B, and C. A being the worker is free from the control and direction of the employer in connection with their work. B, the worker performs work outside the usual course of the employer's business. And C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the employer. It's a mouthful, right? We're going to break it down. But essentially, you had to establish all three elements of the test, and the burden of proof was on the employer, not the other way around. So the court starts with the presumption that this worker is an employee, and it's on you as the employer to show that no, they meet A, B, and C, so therefore they're an independent contractor. The court recognized that Part A, the issue of control, could be subject to dispute and said that Part B and C are clear. So we're going to start our analysis with Part B and C, and then we'll circle back to A. So Part B, the worker performs work outside the usual course of the hiring entity's business. This begs the question, what is your business? So let's take, for example, kind of a classic independent contractor situation, which is you have a magazine or a newspaper trying to hire writers, right? They're looking for somebody to write an article on a particular topic. So they send out emails, they advertise, anybody interested in writing this article, send in your submissions, and we'll pick somebody, hire you as an independent contractor. That's how it's always worked in the past. However, under this Part B, I don't think you can say that in that case, the worker is performing work outside the usual course of the magazine's business. Because what is the magazine's business? It's to publish content. What are you hiring somebody to do? To write content. So you can see how this makes it really, really tough for companies to actually show that their independent contractor is truly an independent contractor. So the purpose is to classify as employees those workers who perform work clearly comparable to actual employees. So for example, a plumber who's working on a bathroom or an electrician installing a new electrical line at a retail store will pass Part B, but a bakery hiring cake decorators to work on custom designed cakes will not pass Part B because they're engaged in the same business. So the key inquiry is, are the services necessary to the business versus incidental to the business? Okay, moving on to Part C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the employer. So an independent contractor ordinarily has been understood to refer to an individual who independently has made the decision to go into business for themselves. That person generally will take usual types of steps to establish and promote their own business, such as incorporating their business, getting the proper licensure, advertising, and routinely offering to provide services to multiple potential customers. The freedom to set somebody's schedule used to be something that really pointed to a worker being an independent contractor. Now, that's not going to be enough anymore. So courts have held that the degree of control is no different when you're knitting at home, for example, at midnight, than if you produced that same work between 9 to 5 in a factory. So a question we get a lot is, what if my vendors use independent contractors? Well, in California, there's a labor code that imposes joint liability on both employers and temp agencies or vendors for violations of wage and hour laws, as well as failure to provide workers' comp coverage when you meet those certain requirements there. In those situations, there is no joint employer control analysis. There are no waivers, although indemnity is allowed. So I think it's a good idea to check your agreements with your temp agencies or your other vendors to make sure you have that indemnification language in there. Okay, so moving on to a federal case, Troyster v. Starbucks, which hopefully you all have heard of. This is a timekeeping case. So essentially there we saw Troyster, who worked for Starbucks as an hourly shift supervisor. Starbucks had a store close procedure that was part of his job duties that included turning on lights, turning out the lights, turning on the alarm before he left, locking the doors, and walking coworkers to their cars. On average, this did not take a lot of time. It took anywhere from 4 to 10 minutes off the clock per shift. And when the court actually broke it down and experts did all their analysis, we're talking about $100 in unpaid wages for Troyster. However, he brought a wage and hour class action. Normally, the defense has been de minimis doctrine, right? However, the California Supreme Court held that California can and has routinely shown to be more protective of employees than federal law. Nowhere in the law does California adopt the de minimis standard, but the court didn't say that this standard doesn't exist. It just said the de minimis standard did not exist under the facts underlying the Troyster case. And the court in Troyster focused on the fact that even though Troyster was experiencing only a couple of minutes of off-the-clock work, that was happening every single day. It was a regular occurrence. So therefore, he was owed those wages, and with current technology, employers can try and capture that time in a lot of different ways. And the court felt that Starbucks didn't do enough to try and capture that off-the-clock time to make sure that Troyster was paid for that. And I apologize, I think I misspoke earlier and said that this is a federal case. I misremembered, and this is the California Supreme Court case. So this is a bit at odds, so to speak, with federal law. So it'll be interesting to see if this case is challenged later on down the line. And it's also making it kind of difficult for those of you who operate in multiple states to figure out what to do with this, because we've got this weird case out here in California, but other states, you can still rely on the de minimis doctrine. Okay, let's move into, this is a federal case, Epic Systems. It's actually a compilation of 3 different federal cases in which the United States Supreme Court decided an issue regarding arbitration agreements that I'm sure you probably all have heard about at this point in time. So each of these cases arose when an employee who had signed an employment agreement that contained an arbitration provision filed a lawsuit in federal court seeking to bring both individual and collective claims. The employers in those 3 separate cases argued that under the terms of the arbitration agreements, the employees needed to go to individual arbitrations. And in this instance, the Supreme Court actually agreed. This was a very good thing that happened for employers last year. So what do we do with all of this? First and foremost, I think that putting a training program together to make sure that those of you who operate in California are complying with the new harassment training requirements, especially for non-supervisory employees, is going to be really important. If you are new to this, let's say you're a much smaller employer and you've never had to do this training before, so you don't know how to go about implementing this, talk to your attorney so you can get some guidance on what the best way to go about this is. Make sure that you have an appropriate space for lactation accommodations. If you use port trekking, make sure you have a system in place to watch the blacklist, and then make sure you're kind of at least considering some of those contractual measures we talked about earlier on in this presentation. Fourth, make sure that management is protecting against harassment by third parties, including customers. I would highly recommend you do the bystander intervention training as a measure to show you are actively trying to prevent this type of harassment. Fifth, be hypervigilant and prepare for more frequent and more expensive harassment fights in court. Keep in mind that your company culture goes a long way. Happy employees don't tend to sue you, but disgruntled employees do. So the more you can make your employees feel like you're listening to them and you're hearing them and you value them and you respect them and you're treating them fairly, that really goes a long way in terms of minimizing potential liability. But with that being said, For sure, make sure that your harassment policies are updated, because with a lot of these changes in the law, a lot of policies are no longer compliant if they haven't been revised, probably within the last year, I would say. And make sure your investigations are done really timely and that they're thorough and that you're taking prompt corrective action and you're guarding against retaliation. 6, I think you should beef up your vendor agreements, including indemnity, disclosure obligations, and audit rights, which brings me to my 7th point. Audit, know everything that counts, and investigate for startup time and donning and doffing issues. Those are putting on, taking off your uniforms. This would be in relation to the Troyster case. 8, adjust your written policies and train employees to follow and express the seriousness of following those policies. Again, inconsistent enforcement is what leads to a lot of employees feeling like they have been singled out or they're somehow being treated differently or unfairly, and that's when they start to either think it must be because of some sort of protected category, it must be because I just complained about something, maybe I should go talk to an attorney, and you can see how it snowballs. 9th, kind of along the same lines as Troyster, consider technological innovations when it comes to timekeeping. I don't know that it's enough anymore to just say we have 2 time machines and they're located in the same place and that's all that we're going to have. I think you have to at least consider, does it make sense to utilize cell phones and apps and let people log in on their phone? Or does it make sense to kind of redistribute time punch machines and things like that? I think you also have to reevaluate any rounding policies that you have and consider padding a few minutes to employees' compensation to account for a few minutes of potential off-the-clock work time so you don't find yourself in a Troyster situation. And then 10th, don't forget about arbitration. Because of the Epic Systems case, you can require employees to sign arbitration agreements now, and those can include class action waivers. That's a really powerful tool for you as an employer now, and that's a U.S. Supreme Court precedent. So for those of you who don't have arbitration agreements or don't have a new 2019 arbitration agreement that is compliant with Epic Systems, I think now is a perfect time to do that. We're still in the first quarter of the year, so you can kind of spin this story to your employees that, this is a new year, we're implementing some new policies, here's how we're changing things up. I do want you to keep in mind, though, that I think it's Chipotle is finding itself in a very unfortunate situation right now where they did utilize arbitration agreements with class action waivers and are now being forced to litigate these claims on an individual basis in arbitration, but there are so many of them, they're having to fight hundreds, if not thousands, of these cases all at once, individually in different jurisdictions. So there is a possibility that utilizing an arbitration agreement with class action waivers can kind of come back to bite you. I would say this is going to be more of a concern for those of you who are much larger companies that operate in many, many states, if not, nationwide. If that's the case, then I think it's a good time to set up a call with your attorney to really talk through the pros and cons of utilizing arbitration agreements with class action waivers for your particular company. And then lastly, stay up to date. The laws are always changing, particularly employment laws. I've included a couple of resources. This is by no means an exhaustive list, but our firm does a lot of different types of blogs and newsletters. So we not only have some California-focused blogs and newsletters, but we also have industry-specific ones. For example, we have a healthcare related newsletter. We have a hospitality newsletter. We also put out legal alerts. So whenever there is a change in the law, whether it's federal law or a specific state law, not just California, but any big change in state law from an employment law perspective, somebody in our firm will write a short article or blog post about that, and that legal alert will get blasted out to everybody that we have on that list. So if anybody would like to be added to our list for legal alerts, please feel free to shoot me an email and let me know that. I'll make sure my assistant gets you put on that list so that you're the first to hear about any new cases or any new laws that are passed. We always try and give you practical guidance at the end of each of our articles as well, so that you at least have some idea for what to do with that information. But you can always, give me a call or shoot me an email if you want to talk through it further as well. So with that being said, I think that I'll take any questions that we might have. Again, if there are those of you who have questions that we don't have time to get to today, please feel free to give me a call or shoot me an email. I love talking through these issues with people and kind of coming up with creative solutions that, will work for your business. Or if you have a question that you think is maybe too long or you don't want to ask it, in a more public forum, please feel free to reach out to me.
Thank you very much, Miranda. We do have several questions, and we'll try to get to them in the next 4 minutes. Maybe we can stay on for a couple minutes afterwards to see if we can get to all the questions. If we can't get to the question, we will follow up by email with a response. So, Miranda, does your firm offer preventing sexual harassment in Spanish, or do you have any suggestions for where Spanish training can happen?
I know we have several Spanish speakers in our firm that could teach it. I don't know offhand if they have done it, but I would have to imagine that they have, or that they very easily could do that. So yes, I would think that's something we could do.
Okay. And what's the likelihood of SB 1300 to be adopted by other states?
That's a great question. And it's going to be dependent on the states, right? So I think your more conservative states, the chance of an SB 1300 type bill being adopted anytime soon is much more remote. But for your more liberal states, I think there's a good chance that some sort of iteration of SB 1300 will be adopted if it hasn't already. I wish that we could cover a lot of states in more depth, but with just an hour time frame for these presentations, it's always tough. And I usually default to California because California is much more liberal, much more progressive, usually at the forefront of bills that are going to kind of set the trends for the rest of the country. So if anybody has questions about a specific state, please feel free to reach out to me. We have some in-house attorneys that do a lot of lobbying type work that I could probably loop in for some more insights. But in a more general sense, I would say the more liberal the state is, the better chance that you'll see a bill like that, if not already.
Okay. And our next question is, what would you recommend as proof of employee training for preventing harassment?
That's a great question. So usually when I teach harassment trainings, I tell my clients to make sure that they have somebody there checking in, attendance purposes. So there's a sign-in sheet, and then also make people sign out so you can show they stayed the whole time, and then give them some sort of certificate of completion so that you can prove they were there, they stayed the whole time, they took something away, from this training.
Okay. Regarding SB 826, how is principal office defined, and does this bill apply to foreign corporations?
Let me just go back to that bill really quick. I don't always remember the the numbers of
This
the
is
bill
the
offset.
regarding the females in on the board of directors.
Oh, the board of directors.
Right.
What
So
was the question again?
how is principal office defined, and does the bill apply to foreign corporations if it's a publicly traded foreign corporation?
That is a great question, and I will have to go back to the bill to check to see if they actually define principal offices. Usually I will try and, in my presentations, either put a term that's defined by the bill in quotes, like I did for female, and I'll try and point out what the definition is. So if my memory serves me, I don't think principal offices is actually defined by the bill. So if it's not, then I would say what we would look at is, where is your business headquartered? Where do most of your executives or, your higher level management, where are they located? And if that's in California, then I think you would want to default to abiding by this law, even if you are a foreign corporation that might have, locations elsewhere. But that's a really good question. If that person wants to shoot me an email, I can double check that for you.
Okay. Next question. Does the Me Too legislation require employers to disclose harassment firing to future employer reference checks? So if somebody was fired because of harassment situations, is the employer required to let future employers know about that if they call in for reference checks?
That is a great question, and I think it's really gray right now. I am not aware of anything that specifically requires you to tell a subsequent employer about that. If you chose to, you would have protections under the defamation bill, so that employee could not sue you for defamation, for example. And in some instances, or I guess on one side of the coin, I think arguably you might need to disclose that from a failure to prevent perspective. I'm kind of envisioning plaintiff's attorneys trying to sue potentially a former employer for failure to prevent harassment if they didn't say something to a subsequent employer and that harasser did something else, at their subsequent employer. But there's also a lot of reasons why you might not want to say anything. One of those reasons used to be fear of getting sued for defamation or things like intentional interference with business advantage and things like that. So it's a long way of me saying I'm not aware of anything that requires you to do that. If you think you might want to do that, I would give your attorney a call just to kind of hash out the pros and cons first.
Okay. And what is port trucking, and where can we find the port trucking blacklist on the internet?
If you will shoot me an email, I can send you the link for the blacklist. But port trucking companies, if you think there's a big port in Long Beach, for example, so there are a lot of companies that will pick up shipments that get delivered to that port and then deliver them to you. So one big example is car dealerships. We represent a lot of car dealerships. So the cars will get delivered to the port. A separate company will pick those cars up and deliver them to the dealership itself.
Okay. Two more questions, and then we'll take the rest of the questions on to a follow-up situation. So if all the employees in an organization are male, do you still need to do harassment training?
Yes. Yes, because harassment is not just males harassing females. I personally have seen every combination. I have a handful of cases right now that are female plaintiffs alleging harassment by female supervisors. I've also seen males and males, and I've seen male subordinates accusing their female bosses of sexual harassment. So yes, it doesn't matter if your entire workforce is one gender or not, you still have to engage in the training.
Okay, and very similar question, but I'll ask it anyway since somebody else asked it. If the majority of employees are female, do you train for everyone or you just train the males?
You train everyone. Yeah.
Okay.
Harassers are usually equal opportunity harassers, so it doesn't matter if they're male or female.
Right. Okay, so we do have not much time left. We're about 5 minutes over, so I have a few more questions. I will follow up by email responses. So thank you everyone for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you, Miranda Watkins, for your time and expertise today. We hope all of the attendees found today's webinar to be a valuable use of your time. Be sure to join us on March 5th for Stress Management, Real Tools for Work and Life Balance. Thank you very much and have a safe day.